How's Jen? Really? It's good? Fun?
No, it's really not, but I'm blessed to be alive.
Well, that's a good attitude to have. That really is, because it could be a lot worse. You could always do some food under it.
Right.
Your lawyer is asking me to set you a bond, but I'm really concerned. This case is very old, and you've been out literally. She's been on the lam for 10 years, Dave?
Well, the warrant was on November 9th, 2015 for this one judge. But the surrender for the judgment roll was on, well, actually the enrollment date was February 16th. Surrender notice to file was April 2020. So I don't know where the FCC went, but the actual forfeiture date.
Do you know, do they really want, are they going to come?
Like with the other ones, the initial teletype confirmed me that the warrant is valid and they do still want it.
Mr. Kim has tried to reach out to the demanding jurisdiction to see how serious of the case is it. Are they really going to come back? But he's been unable to reach anyone. And I mean, it's only been 30, 45 minutes. So, your lawyer's asking me to set you a bond. Because of the nature of the case, the type of case it is, and because of the age of the case, you're asking for.
Your Honor, the state's asking for $10,000 because of possession of controlled substance with intent for oxycodone and the fact that it's been in forfeiture status since 2015. This isn't one where it's a to be warrant. It's one where she appeared in front of the judge, said she would return, and then she didn't.
You want
$1,500, Judge. My client has expressed to me that she is a college student. She has expressed to me that she only works for, because she's in school, Uber and DoorDash. She has expressed to me that she has an attorney that is working because she doesn't want this behind her. She can't have this when she graduates in May, if I'm not mistaken. I have explained to her the ramifications if this court was to give her the bond, that she has to either, that attorney either has to get her a date set there or she has to go turn herself in within the 14 days. She does not have any other criminal history or connection or contacts with police that were dismissed or otherwise, except for this one case from 2015.
You know, thing is that I have to set your bond sufficiently high so that you understand that we mean business. I'm not going to play this game with you again. If I set you a bond, only going to be one time. I won't do it again.
This is where bond becomes more than just money. A judge doesn't set bail simply to punish someone. It's meant to ensure they return to court. That's why Judge Boyd warns this is a one-time opportunity. If she walks away from it again, the consequences could become much more serious.
You need to understand that there are serious consequences with the actions that you take now. I'm going to set you a bond. I'll set your bond at $5,000. And if and when you make bond, we give you 2 weeks from the date of your release to go turn yourself in to that jurisdiction where you're wanted from. Mr. Kim, where is it?
The account.
So you have to go turn yourself in. If you fail to do that, I will revoke this bond. I'm going to set it at 0. I will issue a nationwide warrant for your arrest. Obviously, you can't run forever, right? We're going to get you again, and this time I will physically hold you until Louisiana comes to get you. Do you understand?
Yeah.
Okay.
So just knowing that, he has made the bond for $5,000, is that something that you can, or you or your family is able to post? Because if not,
5,000 cash?
it's $5,000.
Oh no, I have a death baby. I'm single parent. My husband died 3.5 years ago. I'm on a fixed income. That's why I do DoorDash, and that's why I do Uber on the side, just to help,
So I said that to say that the waiver, if he sets the bond, then the waiver goes away. They don't come and get you. You don't get to have the bond and wait for them at the same time to see which one happens first. So if you're not going to be able to pay the money, then you can, the option is to leave the waiver that you have in place that you signed on, I think 2/27, and then let them see if they're going to come get you or not. But you don't lose the time that you've already been in custody.
So when you buy, I'm confused, when you buying,
Okay. Who did it you with?
227?
So you have 1, 2, 3, 4, 5, 6 days credit. We give them 14 days to come get you. If they don't come get you within the 14 days, we release you. They file a dismissal, I sign it, and then they let you go. If that happens, the warrant will always remain active. And that warrant will always remain active until you physically go back, somehow go back to Louisiana and take it.
Here's the difficult choice. Keep the existing waiver and wait to see if the demanding state picks her up, or post bond, lose the time she's already earned in custody, and take responsibility for turning herself in. Neither option is easy, and that's exactly why extradition hearings can become so complicated.
That said, if you want to make this bond, you have to withdraw that waiver that you have, and then you lose those 6 days. So if you withdraw it and you don't make the bond, you lose all that time, and you basically it's hold until you re-waive or you make that bond.
No one here in case I didn't know if you had counsel in Mississippi. Very, very rare, but I have been seeing it happen here and then, or here and there, is if local counsel there can get a new setting. Like I said, it's incredibly rare. I can count on one hand the amount of time.
What do you mean get a new setting done?
So even if they don't appear with sufficient evidence, the Marsh Sheriff's Office says she's in our custody and her person is here, and for a variety of factors I can't speak to Mississippi because I'm not licensed, I don't work there, is whatever sufficient factors they have to set a new date for her self-surrender versus outside of the fugitive if they call it warrant. So I guess it's incredibly rare, but only because of the age of the warrant and the fact that she has counsel there. Yes.
Well, but we don't know.
Well, what I'm saying is the information for that counsel. Okay.
I mean, I'm not going to give you a PR bond. This case is 10 years old. You can really just, I need you to understand that we mean business. I'm not here.
Notice the judge's message here? It isn't about being harsh. It's about accountability. From the court's perspective, someone who missed court once has to prove they won't do it again. That's why the amount of the bond matters almost as much as the promise behind it.
Here to play games. So that's why we have to set it sufficiently high so that you realize that you have to have skin in the game so that we know that you're going to go back. I'll let you guys talk about it. I don't want you to make a decision here in front of everybody. So you guys talk about it. You know, I'm not stuck on the 5,000. I go back down a little bit, but it's not going to be much, you know?
I'll stand down, Judge.
Sure. So hold on. Hey. So
Yes.
I'll let you guys go talk. I want you to say something here that you might invariably regret because it's in front of everyone, you know?
Asterisk, this hearing ends with the judge giving the defense time to think instead of forcing an immediate decision. Sometimes the biggest courtroom battles aren't about guilt or innocence. They're about making the smartest legal choice. What would you do in this situation? Let us know in the comments, and subscribe for more real courtroom breakdowns and legal analysis.
Thank you.
Thank you,
I'll
Judge.
go down, you know, a reasonable amount.
You gotta do this.
Oh, yeah.